Namaste, friends, and welcome to the Legal Words of Wisdom Nyay Ganga on our Virat Hindustan Sangam social media channels, which we air on every Saturday at 8 p.m. Indian Standard Time. And as you know, Dr. Subramanian Swamy and our guest, Dr. Venkat Iyer, who is a barrister based in UK, discusses many aspects of the Indian legal system and discusses things which can be useful to the common man. So today we are back, and today is going to be the second part of the contempt of court myths and reality. We will be discussing what happens when judges are criticized in the media. Is the law in this area out of date? What exactly is the concept of scandalizing a court? How has this law been used in India? What lessons can we learn from decided cases? What can be done when judges misbehave? Can truth be used as a defense in contempt cases? These are some of the issues that will be discussed in this 12th episode of Legal Gyan Ganga, Nyay Gyan Ganga, which we have started about 12 weeks ago. You know that on Sunday we have our regular program, Words of Wisdom Gyan Ganga, in which Dr. Swamy at Sunday 8 p.m. Indian time also discusses numerous other topical current issues. With this, I am welcoming Dr. Swamy and Venkat Iyer to our show. I thank my co-host Ramesh Swamy for being with me on this show, and I also thank our technical team led by Ashish Shetty, Vishal Mehta, Ishwar Iyer, Tejas Swaminathan, and Rakesh Gadgi for their support in putting this episode together and doing the background technical and commercial activities. So with this, it is over to Dr. Swamy for his opening remarks. Over to Dr. Swamy on this issue of contempt of court.
Thank you very much. Again, as last time, I think I will make a very brief comment. And then towards the end, when we are concluding that time, if I have further to add, I will intervene. In the beginning, Venkat, you spoke about the distinction between criminal contempt and civil contempt. And I think this much must be further clarified, that when in the civil contempt, which is essentially means failure to comply with the order of the court. So this has been a big malady in our country. People get orders from civil court, and then the person who is supposed to implement it, he doesn't do it. And one excuse and after the excuse, and civil contempt is something that I think needs to be further developed. So you might throw some light on this. Second thing is the criminal contempt, which arises from Article 129, and perhaps for the High Court from Article 215, is to protect what? The reputation of a court as an unbiased institution, and in particular the reputation of judges, because all kinds of allegations keep flying. And so the point that you raised about the truth, I hope you will give it a little sharper focus, if briefly, because you did cover a lot of it last time, and then conclude as to whether we are through with amending the contempt law or there's more amendments necessary. Thank you. Over to you.
Yep, thanks. I want to get straight into a continuation of what we were discussing last week, because the time at my disposal is limited and there is so much that can be said on the topic of contempt. So let me start with the second type of contempt, one which has been causing huge problems in India. It is called scandalizing the court or scandalizing a judge, depending on the context. And it consists essentially of attacks, that is, words or actions that are so scurrilous that they are likely to undermine or shake public confidence in the administration of justice. In times long gone by, of course, the threshold for scurrilousness was quite low, and even relatively mild attacks on judges would be considered unacceptable. To give you an example, an English newspaper in 1900 called a judge who was memorably named Justice Darling an impudent little man in horsehair. The reference to horsehair being to the wigs that judges and barristers wear in court in the UK. And the newspaper also added that this judge was a microcosm of conceit and empty headedness. So strong was the paper's hatred of the judge that it also repeated an unkind remark which was made by someone else about him to the effect that because an eccentric relative had left him a lot of money, he ended up becoming a judge rather than a successful bus conductor. The newspaper was fined £100, which in today's money would be close to £10,000. But as the years went by, prosecutions for scandalizing became rarer and rarer. And by the 1980s, even the House of Lords admitted that this offense had become obsolete. Interestingly, it reared its head up once, and by coincidence in Northern Ireland, where I live, as recently as 8 years ago, when a cabinet minister was prosecuted for saying that a certain High Court judge had, in his words, gone off his rocker for questioning the conduct of senior civil servants in a very high-handed and idiosyncratic manner. But the prosecution was dropped after the minister made a statement that did not question the judge's motives or his capabilities on the bench. The offence of scandalizing, incidentally, was formally abolished in England in 2013. There have been many occasions in recent years when the UK media have criticized judges sharply, and yet no action was taken. Some of those examples have been cited recently in India during the debate over the Prashant Bhushan case. So I shall not spend too much time describing them. Two of the most prominent are worth noting. First, the action of a newspaper in publishing the photographs of three judges of the House of Lords upside down on the front page under a huge headline screaming, "You fools," all in capital letters, after those judges had given a controversial ruling in the Spycatcher case in 1987. And secondly, more recently, there was a publication of a similar headline by another newspaper which called the judges who decided the Brexit case, which was at an intermediate level, enemies of the people. There's also an instance a few years ago when the Economist magazine, after being compelled to pull out a review of a book review on grounds of defamation risks, left the page blank, but stated at the bottom, "The law is an ass." In none of these cases was any action taken because, as the British judges have frequently stated, they consider their shoulders to be broad enough to accept such criticism. I would argue as well that if a judge has the necessary self-confidence and is not insecure, as sadly many Indian judges are, they'll be able to brush off unfavorable comment without batting an eyelid. Let's now turn to some Indian cases on scandalizing. One of the first to arise involved the former Chief Minister of Kerala, the late Mr. Namboodiripad. As a communist, he was not a great fan of judges trained in the Anglo-Saxon tradition, as all Indian judges are. So, during a press conference, he said some rude things about judges in general, calling the judiciary an instrument of oppression and judges as dominated by class hatred and class prejudices. And he also said that judges would instinctively favor the rich against the poor. When he was charged with contempt, he defended himself, arguing that he had no intention to disrespect the judiciary, but was simply giving expression to the Marxist philosophy to which he subscribed. This defense was rejected, and he was fined 1,000 rupees or asked to suffer imprisonment for 1 month. He appealed that decision to the Supreme Court, which, in a lengthy judgment delivered by Chief Justice Hidayatullah, upheld it, noting, some would say gratuitously, that Namboodiripad had misinformed himself about the teachings of Marx and Engels, and that his remarks had the tendency to create dissatisfaction among the public towards judges and thus weaken the authority of the courts. But the Supreme Court reduced the fine to a token 50 rupees or 1 week's simple imprisonment in lieu. Many people thought that the Supreme Court was wrong in taking the line it did, not only because Mr. Namboodiripad had specifically and unreservedly accepted that the verdicts of the courts needed to be respected, despite his criticisms of the judiciary as a whole, but also because the judgment signaled an unreasonable restriction on freedom of expression. Let barking dogs lie was, they thought, a better approach to take in the face of such criticism. Something similar to Namboodiripat's criticism, but this time in a more virulent form, came in 1987 from a serving minister in Indira Gandhi's cabinet, a man called P. Shivshankar, who had himself been a High Court judge before stepping down from that position and entering politics. Shivshankar lashed out at the Supreme Court in a speech, arguing that it was composed of an elite class of judges who had unconcealed sympathy for zamindars, antisocial elements, foreign exchange violators, bride burners, etc., all of whom, he said, had found in the Supreme Court a heaven. I think he actually meant heaven, but let's not quibble about his language. Strong stuff, but the Supreme Court this time rejected the contempt petition and distanced itself from the view that Hidayatullah had taken in the Namboodiripad case. It is worth noting that in between these two cases, there had been two other related cases in which immediately after the 1975-77 emergency, articles had appeared in the Indian Express and the Times of India in which certain criticisms had been made about judges, and these were pretty sharp criticisms for their cowardly behavior during the emergency and for the Supreme Court having been packed by Mrs. Gandhi. Those cases were promptly dropped by the court, although in both of them, the then discredited Chief Justice, M.H. Beg, tried lamely to defend his highly controversial stance in the habeas corpus case. Amusingly, one of those judgments saw a judge, Justice Kailasam, have a dig at his colleague, Justice Krishna Iyer, for writing what he called an inconclusive essay based on hypothetical questions which had no relevance to the case. Such, incidentally, are the joys of what sometimes comes out of the Supreme Court of India. Talking of Krishna Iyer, he himself was accused of contempt around 1981 when, after stepping down as a judge, he made some very strong criticisms of the judiciary in a speech that he delivered in his home state of Kerala. In keeping with his leftist background, he said things like the people will one day rise against the Supreme Court because of its class bias, and that the hearts of the Supreme Court judges bled when they saw property rights being taken away in the bank nationalization case, etc. But in a lengthy judgment in which the two judges who heard the case controversially expressed their undiluted admiration for Krishna Iyer, they nevertheless dismissed the case. Now, sticking with criticism of judges, there was one slightly unusual and, I would say, entertaining case which arose in the Delhi High Court in 2001. It concerned a little-known magazine called WAH India, WAH, which published an article that revealed the results of a survey apparently carried out by the magazine about the integrity and competence of judges attached to the Delhi High Court. In the survey, some 50 senior lawyers practicing that court were asked to grade the judges on the basis of personal integrity, depth in law, and the quality of judgments delivered. It doesn't say if other attributes were also surveyed, for example, punctuality, politeness on the bench, promptness in delivering judgments, etc. I would say that if the magazine was mischievous, it could have also asked questions like, is the judge fully alert while hearing cases, or does he take short naps, as some judges do, or does he check his mobile phone for messages, or ask his clerk for periodic updates on a cricket match, which also, believe me, happens in some courts. Unfortunately, no copy of the article in question is available, so I've had to rely only on the judgment given by the court, which is short on details. Anyway, when the editor of the magazine was charged with contempt, it was a lady called Madhu Trehan, quickly apologized. But the court was not satisfied that the apology was genuine, although in the end it accepted the apology by a majority and ordered not only that the sales of the issue in question will be immediately and comprehensively stopped and all existing copies seized, but also that the apology tendered will be published in 5 national dailies. An interesting aspect of this case is that initially media reporting of it was banned, but that ban was lifted after strong protests from journalists. I now want to discuss one major case which was the trigger for an important change to the law on contempt in India. That case is, the formal title of the case is V.M. Kannade and Madhav Gadkari. And it began in the Bombay High Court, which gave judgment in 1989. The facts are most interesting. The defendant, Madhav Gadkari, was a well-known Marathi journalist who wrote a popular column in Lok Satta newspaper, of which he was also the editor. In one of his columns, he discussed some worrying trends in the Bombay High Court. Specifically, he made 3 criticisms which became the subject of the contempt case. The first point he made was that one of the judges in the High Court was amenable to the seductive charms of a certain lady advocate, with the result that this judge would pass orders favorable to the party for whom the lady in question appeared. The second point Gadkari made was that there was another judge in the High Court who was deaf and had the habit of switching off his hearing aid when he did not want to hear any advocate. And the third point he made was that the Motor Accidents Claims Tribunal, which in Bombay is called MACT, which hears cases for compensation in relation to motor accidents, was, in his, that is Gadkari's words, a plain racket, because, among other things, 2/3 of any compensation awarded in that tribunal was swallowed by the lawyers and the judges involved in the cases. He also made the point that the tribunal was situated on the 5th floor of a building whose lift was perennially out of order, which, considering that it heard accidents cases, was disgraceful, since many of the plaintiffs would have suffered injuries that would have rendered them disabled and therefore incapable of climbing stairs. On being charged with contempt, Gadkari indicated, in effect, and through his lawyer, incidentally Ram Jethmalani, that he stood by everything he had said and was willing to prove his allegations. The law, unfortunately, did not allow that. Another part of Gadkari's defense was that he wrote the article with the best of motives, with a view to improving the sad state of affairs prevailing in the judiciary. Neither of those arguments cut the mustard with the judges, and they held him guilty, sentencing him to a fine of 100 rupees or to imprisonment for a week in default. Mr. Gadkari was unhappy and he filed an appeal in the Supreme Court, which promptly stayed the judgment. Since that appeal did not come up for hearing for quite some time, and since I was curious to know about the fate of it, I rang Gadkari sometime in late 1990s to ask what was happening. He said he had absolutely no idea, and he added, "Your guess is as good as mine." He then turned the tables on me and asked if I would be kind enough to let him know if I heard anything about the fate of his appeal. And he meant it through my legal colleagues. And sadly, a few years later, Mr. Gadkari passed away, which means that his appeal would have abated. But that was not the end of the story, because Parliament decided in 2006 to amend the Contempt of Courts Act to allow truth to be pleaded as a defense to a contempt charge, provided that the defendant could also show that there was some public interest in such a defense, as well as good faith in raising that defense. One can consider that amendment as a legacy from the Gadkari litigation, although a recommendation for such an amendment had also been made in 2002 by a commission that had been formed to review the working of the Indian Constitution, that is the Venkatachalaya Commission. What does the amendment mean in practice? It means that while a person charged with contempt can attempt to prove the truth of what he had said, he cannot bring in matters that would not be in the public interest. An example might be a statement which makes scurrilous allegations about a judge's private life, which are wholly unconnected with the performance of his duties. And then an attempt is made to justify those allegations in open court during contempt proceedings, which of course can then be lawfully reported in the media. This would amount to washing dirty linen in public, which of course cannot do any good for public confidence in the judiciary.
Yeah.
But we need to remember that such a situation might also give rise to a defamation action by the judge, about which I had spoken previously. Now, I've not been able to find any case in which a person charged with contempt through scandalizing has attempted to prove the truth of his allegations under the amended law. There was one case, however, in which the truth of certain remarks made in I think it was an editorial in a specialist tax law journal, was accepted by the Supreme Court. But here, no one had actually challenged the truth of those remarks, and the contempt petition was dismissed anyway. And of course, last week, Swamy referred to a contempt petition that he had filed against Arun Shourie, in which also truth was raised as a defense. But that petition did not go very far because it was dismissed principally on another technical point. Maybe Swamy can talk more about it when we have a discussion at the end of this talk.
Yeah.
There is one case where I can see the possibility of the defense of truth being used if contempt proceedings had been brought. But as far as I know, no such proceedings were actually brought, and rightly so. It's a case which happened in Chandigarh, and it involved judicial corruption. The facts are as amusing as they're astounding. A bag of money containing, I think, 15 lakhs of rupees was delivered at the home of a sitting judge of the Punjab and Haryana High Court called Nirmaljit Kaur, and it was meant to be a bribe. The intended beneficiary of the bribe was actually another judge in the same High Court called Nirmal Yadav. The courier who was entrusted with delivering the bribe turned out to be incompetent, and it led to Nirmaljit Kaur being startled by the arrival at her doorstep of this unexpected bounty. She promptly reported the matter to the authorities, who, after some investigation, quickly discovered that the identity was quite easy to ascertain, not only of the bribe taker, but also of the bribe givers, who were a couple of businessmen aided and abetted by a practicing lawyer and another person, probably a middleman. The matter was duly reported in the media, but if the journalists who had reported it had been charged with contempt, I can see that they could have easily used the defense of truth, coupled with public interest and good faith. But quite sensibly, no such charges were brought because everybody involved must have recognized that this was a case which deserved wide publicity. Incidentally, cases of judicial corruption are not easy to prove, at least not for the media, because no bribe giver is likely to own up to his misdeeds. Underscores there was a sting operation, which is a topic I intend to discuss in a future episode in the context of a different area of the law, or if there were credible witnesses, or if it was possible to get supporting evidence through a right to information request. But other forms of judicial misbehavior are frequently reported, and most of the time, those reporting them or commenting on them are not charged with contempt because what they're doing is manifestly in the public interest. However, there are aberrations, and I'll give you an example which caused a lot of public and media disquiet a few years ago. It involved stories in a number of newspapers, including highly respected ones, to the effect that 3 judges of the Karnataka High Court had been seen consorting with females in a luxury resort in Mysore sometime in late 2002. There were significant variations in the details of these stories, some of them suggesting that the females involved were advocates, others indicating that they were aspirants for judicial positions or it could even have been judicial promotions. But one thing that was clear in all the reports was that whatever these females and the judges were doing at the resort, they were certainly not, shall we say, discussing finer points of contract law or considering reforms to reduce judicial arrears. Their activities were of a more personal nature. In fact, the mildest term that the newspapers used to describe the happenings was sex scandal. Some of the papers used more colorful language, which I shall leave to your imagination to guess. Because the story was sensational by any standards, the authorities were compelled to act. The Supreme Court of India immediately constituted a 3-member in-house committee to investigate the allegations, and that committee came to the conclusion that the allegations were not substantiated. Immediately thereafter, 14 publications were charged with contempt, although I believe that proceedings against 3 of them were subsequently dropped. The publications in question stood by their reporting and pleaded not guilty. A sidelight of this incident was that the High Court also demanded that the newspapers should reveal the sources of their stories, a demand which the newspapers stoutly resisted, arguing that they enjoyed journalistic privilege. That is an important issue which I plan to discuss next week. Another interesting sidelight was that when a lawyer who was unconnected with the case filed a writ petition asking for a copy of the report of the in-house committee, which had exonerated the judges, the Supreme Court turned down that request, which was seen as going against the principle of transparency and judicial accountability. I'm afraid I've not been able to find out what happened eventually to the contempt charges against the newspapers, but my guess is that they were dropped. Judicial misbehavior of whatever kind does merit wide publicity in a democracy. And the media cannot, and I would say should not, be threatened with contempt cases when that happens. And if it's any consolation, let me tell you that misbehavior by judges is not a uniquely Indian phenomenon. It happens quite frequently in other countries as well, nowhere more so actually than in the United States. As we come to the end of this talk, let me give you a few examples from that country. And these are, I must say, just the tip of a huge iceberg. There was a case involving a judge called John Murphy of Florida, who, after taking a dislike to a public defender who had been appearing before him in a trial, bizarrely challenged the defender to a duel in the hallway outside his own courtroom. A challenge which was accepted equally bizarrely by the lawyer. They got into a spirited fight in which the judge kept throwing punches at the lawyer until the two were separated by a court official. This is by any reckoning conduct unbecoming of a judge, and it was widely reported and condemned. In another case in Texas, a judge burst into the jury room and told the jurors who had just found a defendant guilty of sex trafficking that God had told him that the defendant was innocent and therefore they, that is the jury, should reconsider their verdict. Again, totally unacceptable conduct, which was very widely reported. In yet another case, this time in Indiana, 3 judges, 2 male and 1 female, who had been attending a conference, got drunk and started a brawl with strangers outside a fast food outlet at 3 in the morning. Their late night adventures resulted in 2 of them getting shot and sustaining serious injuries, which needed urgent operations and lengthy periods in hospital. This incident, too, was reported extensively without any threats of contempt to the media outlets. Drunken behavior has, of course, accounted for scores of cases involving judges. A few of those stories would be more outlandish than that of a judge in France who, after getting sozzled, stopped a police car outside a bar, mistaking the police car for a taxi. He later said that both types of vehicles had flashing lights on their roofs, and that is what confused him. When he asked the policemen inside to take him to where he was staying, and they refused, he kicked and punched them, whereupon they did give him a ride, but to the local police station, not to his home. So intoxicated was the judge that he still did not realize the folly of his actions, and he started biting 2 other policemen who were in the station. He had to spend the night in a lockup. The incident again received extensive media coverage. There was no suggestion in any of these cases that by drawing attention to such misbehavior of the judges, the media were interfering with the administration of justice in any way. On the contrary, it was accepted that they were performing a valuable public service. I'd hoped to finish our discussion of contempt this week, but I realized as I was planning today's episode that I may not be able to achieve that objective. And so it has actually turned out to be, because I know that I'm coming to the end of my time. And there's still a lot to be said. So the many things that I intend to keep for next week's episode are, for example, other ways in which contempt law can affect the media and the public. And Swamy made a very important point at the start of the talk about civil contempt also coming in that category. Also, the impact of contempt law on investigative journalism, particularly in corruption cases, on how contempt law deals with the confidentiality of a person's sources, and what happens when unreasonable reporting restrictions are made by judges, and so on and so forth. There are quite a few things more to be discussed. I also want to talk about the defenses that are available to anyone who is charged with contempt. So, in consultation with Jagdish, I am planning to continue this discussion next week, but I'll stop here for the present. Thank you.
Well, thank you. Very interesting and very learned presentation you made today. There are 2 things I'd like to suggest you might consider for next time. One is that if I'm in court and I make a defamatory comment not about the judge, but about the fact that the plaintiff, if I'm a defendant, I'd say the plaintiff has tried to fool the judge by presenting rubbishy material in his thing. Now, I believe there are 2 safeguards for a person who, as a lawyer, in arguing a case, is protected by. One is called absolute privilege, and the other is called relative privilege. I think
Qualified privilege.
Qualified privilege. Yes, that's right. Qualified privilege. Perhaps you could deal with that a bit, although it's peripheral to the defamation of judges. But the extent to which advocates, while arguing, are at liberty to make defamatory statements about the plaintiff or the defendant, as the case may be. The second thing you asked me about Arun Shourie, it was like this. Ramkrishna Hegde was, I had caught him on a major corruption action. I had earlier on got him removed from the chief ministership by a meeting of the parliamentary board of the Janata Party, of which I was a member, because he had ordered the taping of 51 people, including one of his fellow ministers, Devgowda, and also all the people who might be visiting his girlfriends. So, I mean, these are all established facts. And so, as a consequence, Mr. Rajiv Gandhi decided to set up a commission inquiry on the main allegation of mine, which was the grabbing of very precious land of Bangalore and giving it to his son-in-law's company. So, in the Arun Shourie was, of course, a bhakta of like many intellectuals were of Ramakrishna Hegde, and of course he was all sham, which I later on proved that he was. But he had a tremendous image thanks to the media, and he, of course, wined and dined all the media, and they were all carried away by him, and he was projected as the next prime minister. So at that juncture, this coming essentially destroyed his prospects. And that, of course, I did because we were both general secretaries of the Janata Party, and he kept on creating situations where Chandrasekhar would actually throw me out of the party and made all kinds of false claims. So I decided to retaliate, and that's how it came. Now, what happened is that when Arun Shourie, as the editor of Indian Express, published a long article making fun of Kuldip Singh, the Supreme Court judge who was appointed to head the commission and who found Hegde guilty, he made all kinds of allegations against Kuldip Singh, and so naturally Kuldip Singh was hurt. He was nothing of the kind that Arun Shourie had made him out to be. So I filed as a complainant. I filed a complainant in the investigation of which Kuldip Singh was the chairman. I filed in the Supreme Court a contempt. Now, in that contempt, it was an open-shut case, but then Arun Shourie came up with this, or Shanti Bhushan, I think, was his lawyer. He came up with the argument that we have a defense. That's how the whole defense thing began to take root. Now, so the court posted it before a constitutional bench to decide thing, and it took ages for it to come up in the list and to be heard. When it came up in the list, Arun Shourie was no more. He was no more editor of Indian Express. He was no more. His subsequent post as minister of the Vajpayee government, because Vajpayee government itself had collapsed. Had lost the election, and he was in a number of big troubles himself. Including some deep disinvestment thing and so on. And I knew him personally. Personally, he was a very nice man. But he had a lot of, he was, what shall I say, his family was so unwell in a number of ways that he, literally was, he spent a good part of his life and time looking after his family. So when this matter suddenly came up, I think in 2012 or 13, Arun Shourie approached me, and he knew me well. So there was no difficulty in his meeting me, and he told me that this matter is coming up, and if you are there, I will be definitely I'll have a difficult time. So whether you could be a little more gentle with me. So when the court sat to hear the matter, I was called by the judge. Yes, Mr. Swamy, he said. I said, my job was to bring it to the notice of the court. And the court has to decide whether Mr. Arun Shourie has committed contempt of the court or not. My work is only to was to, as a postman, to bring this fact to the knowledge, and my role ceases after that. And I'm not competent to argue in this matter. So I said I should be excused. And so on that basis, the case was terminated. Because the court felt that I should have argued, but I felt, what is the use of, contempt petition, sending him to jail, perhaps, and in this kind of situation after he has been through all this, and Hegde also had had passed away. So there was no personal reason, there was no law that needed to be established, and I also felt that the charges that he had of his justification were absurd, because if it went through, it would probably hurt him more, and it will also probably hurt some other people whom I knew. So that's why I did not let it. I walked out. I mean, I was justified that it's the job of the person in a criminal contempt case, and you can deal with this, whether this is correct. The contempt is brought to the notice of the court, and then it becomes the property of the court. After all, it is contempt of the court, scandalizing of the court, or now you can't use that phrase, but whatever, lowering the prestige of the court, the impartiality of the court, etc., etc. And Kuldip Singh, as that time was, when he gave the judgment against Hegde, he was a Supreme Court judge. He was asked by the government of Mr. Rajiv Gandhi to sit in a commission inquiry as a sitting judge of the Supreme Court. So I proved this much. I proved that contempt petition would lie, as if Mr. Kuldip Singh was doing his duty as a Supreme Court judge, because he was not doing an extracurricular activity. He was doing it. So this was the reason why it got terminated, never reached a conclusion, and the matter was disposed of on the grounds that I am not pursuing it, and that in view of that, we don't see any reason we should proceed with the matter further.
There was actually a lengthy judgment in that case, which I happened to read just earlier this week, and it said something. They went off on a different point. In a sense, they went off on a tangent. And the question they examined was, is a commission of inquiry the same as a court of law? And therefore, would the Contempt of Court Act apply to a commission of inquiry, even if the commission of inquiry is headed by a sitting judge? And they made the distinction of Kuldip Singh's position between him sitting in the Supreme Court and sitting in the commission as the chairman of the commission. And they came to the conclusion, not just on the basis of that case, but there were a number of previous cases as well, where it was clearly held that a commission of inquiry is not equivalent to a court for the purposes of the Contempt of Courts Act. In other words, because it did not have the power to give a determination, as it's technically called, therefore it is not a court. And so, in a sense, they went off on that tangent and did not get back to what you are talking about in terms of whether that constituted contempt at all, or about whether the defense of truth could be used at all.
Yes, but I think it was a happy ending because I had told Justice Kuldip Singh and his great friend and the man I, as law minister, appointed as the Attorney General, namely G. Ram Swamy.
Oh yes,
brilliant man, but very partisan, who persuaded me that Kuldip Singh is feeling very bad about it. You must take it up. I did take it up, and we did come very far. I'm not so sure how it would have gone, because this particular argument was used by Arun Sherry's lawyers, and there was no challenge. It was between them and had I been there, I would have said a damaged Supreme Court judge from a commission of inquiry is as good as a damaged Supreme Court judge sitting in the Supreme Court later on. the public confidence. I mean, I would have gone on the argument of public confidence.
Yeah.
Can you trust a man who has been found in another matter? You see, if there's a judge who is heading a criminal court, and then he is also charged with murdering his wife, I mean, I think it'd be a very, 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 very artificial distinction between the Supreme Court judge being asked by a government to sit and gets the permission of the Chief Justice. In fact, the Chief Justice recommended this. And I must tell you, there was a subsequent case. I don't want to take up much of your time, but there was a subsequent case when I, as law minister, persuaded J.S. Verma to sit in a commission of inquiry to find out whether the security arrangements made by the Chandrasekhar government for Rajiv Gandhi was sufficient in Sri Perumbudur. And of course, he gave a wonderful judgment, which Narasimha Rao buried it completely, because it squarely blames the Congress party for disrupting the security arrangements which facilitated the assassination of Rajiv Gandhi, and would have led, further proceedings on that would have led to a lot of big people being named. And that's why the Jain Commission was brought in to try and fudge the whole matter and make counter allegations against Narasimha Rao, Chandraswamy, Chandrasekhar, myself, and so on. So this, unfortunately pursued by Mr. Atal Bihari Vajpayee till I spoke for 2 hours in Parliament and demolished the whole case, and in fact showed that by the logic he was, the Justice Jain was using, and the government in their ATR, as it's called, which is filed in the court, filed on the table of the House. I said Mr. Vajpayee could be equally guilty, because just connection to Chandraswamy, he had more connection to Chandraswamy than anybody in the Parliament, and that on that basis, Mr. Advani suddenly got up and said that we have never intended to either draw in Mr. Narasimha Rao or Mr. Chandrasekhar or Subramanian Swamy into this. This is a purely media creation. It's got nothing to do with what we actually meant to do. We just thought that these three could be good witnesses when the investigation takes place.
So I have a question here, Dr. Swamy. And when you mentioned, I think both of you, when you discussed whether a commission of inquiry can be considered a court, what about tribunals? Are they courts essentially? I'm just extending.
No. You're posing the question differently from mine. I'm saying that Kuldip Singh was not a member of the commission. He was requested by the government through the Chief Justice who picked him. And therefore, he is in the J.S. Verma also, there was an attempt, and this is the argument that I, as a law minister, gave, and that was upheld, that in that condition. But the subsequent judgment now stands, because what they have given, what they have decided, what you told me, which I vaguely knew, but that's why I didn't mention it, but that this distinction was made. I consider that an unfortunate. Then no Supreme Court judge will now in future sit in a commission inquiry.
Now, can that commission of inquiry, so commission of inquiry is one, so are tribunals also considered like that?
If the, no, tribunals have their own established judges, chairmen. There's no scope for bringing a Supreme Court judge to sit in a tribunal.
Is it a court of law?
It dispenses law. It is a court of law, yes.
Okay.
But there is an appeal against it.
The short answer, Ramesh, is no. Because what happens is, if there is any contempt of a tribunal or any act which seems like contempt of a tribunal, then the tribunal has to refer the matter to the High Court. And the High Court will then take it up.
It cannot suo motu take action on being contempt.
No, unless the founding statute of the tribunal specifically gives it the power of contempt, which is, in my experience, extremely rare. I've not come across cases like that.
Even commission inquiry doesn't have.
No.
But here the issue was not a contempt of the commission. It was a commission contempt of the Supreme Court that we argued, because he was a judge of the Supreme Court.
So NGT is basically a quasi-judiciary. Can we say that word?
In effect, it is, but in de jure terms, because it has the power to make determinations, it would. I think it would be wrong to call it quasi-judicial, because it does have judicial powers.
Yeah, I mean, it's an implementable powers. That is, if a decision is given by a tribunal, it can be implemented unless appealed against it.
Okay.
And again, there are very different types of tribunal. There are certain tribunals which are now in India as powerful as a high court. So, for example, NCLT, those kinds of tribunals, they do exactly what a high court had done before those tribunals had been set up. In other words, the powers of the high court have been transferred to those particular tribunals, and in those circumstances, they become quite powerful.
So, what about the NHRC, the Human Rights Commission, or the National Commission for Women? They're all just commissions, correct? So there cannot be any contempt proceedings or anything.
No, they're the judicial thing. They
have to refer to the High Court.
Yeah, that's right. They make a finding and that is taken up in the High Court.
Yeah.
But are these, I know slightly off topic, but are the decisions made by NHRC, NCW binding on the defendant?
Actually, there are no defendants in proceedings before NHRC. There is a complainant, and there are people against whom complaints are made. The NHRC does have powers, for example, to summon witnesses, to take evidence, etc. But ultimately, if the order of the NHRC is not obeyed, then in a sense we go back to a point that Swamy raised at the beginning. Then the remedy will be that the matter will have to be referred to the High Court.
Okay. So there's no enforcement. So commissions don't have the power to enforce.
Not in the way that a court's, for example, the High Court will have the power to enforce.
No, it is enforceable if nobody appeals against it.
No, Ramesh, there is another distinction. A commission can be appointed under the Commission of Inquiries Act. And there are some commission like the Human Rights Commission, which is not appointed under the Commission of that other this act, So those are different bodies compared to the Inquiry Commission.
Yes,
am I right?
What we're talking about are
Venkat?
fact-finding commissions. There are certain fact-finding commissions, and there are certain commissions which have the power to determine the rights and wrongs of particular issues. In fact, if we had more time, we could have gone into this issue. I think all of us remember what happened with the Shah Commission. Now, there were many occasions when the people who were indicted before the Shah Commission, not indicted, but who were subject to proceedings under the Shah Commission, including Indira Gandhi, were cocking a snook at the commission. In other words, disobeying, not turning up, etc. And it became very clear at that time that the commission could not do anything except refer the matter to the High Court for action, because the commission itself did not have the power of contempt.
Right.
Okay. Thank you. Okay, Jagdish, I'm done.
Okay, friends. We come to another end of another interesting episode of Legal Gyan Ganga or Nyay Gyan Ganga and Legal Words of Wisdom on our Saturday evening show on Virat Hindustan Sangam channels. So we will be meeting next week for the third part of this continuing series, and that is the 13th episode in our Saturday series. Tomorrow we'll be back with our regular Gyan Ganga Words of Wisdom at 8 p.m. Indian Standard Time. So this is thanking Dr. Swamy and Dr. Venkat Iyer for their useful inputs and discussion on this subject. I also thank my co-host Ramesh Swamy and our technical team led by Ashish Shetty, Rakesh Gadgi, Tejas, Ishwar Iyer, Vishal Mehta and Swaminathan for their support and teamwork for putting this show together. We'll see you tomorrow at 8 p.m. Indian Standard Time for another edition of our Sunday Gyan Ganga Words of Wisdom. Thank you. Dhanyavad. Jai Hind.